Hi, I'm Anna Denton-Jones, and today I want to talk about Higgs and Farmor, a Court of Appeal decision in relation to some Facebook posts of a pastoral administrator at a school in relation to her beliefs. Now, the lady concerned, her beliefs are what might be called in the jargon gender critical beliefs, namely that there are only two genders, you can't change gender, etc. We know that that's protected since the Forstater decision, as equally as people who believe the opposite, so that there is gender fluidity, or that people may have a different gender to that they were born with. So the law has already told us that we're, as employers, having to navigate a tightrope, walk that tightrope where, as an employer, you have to respect the beliefs of everybody, whichever side of the debate that they are on. What had happened in this case was that the lady concerned had posted or commented on Facebook posts, some of which didn't even originate in the UK. It was all from America, expressing her beliefs, if you like, in a way which caused the employer to have concerns about, is this going to damage the school's reputation? Are people who perhaps come from the LGBTQ plus family going to have concerns about working alongside somebody who's expressing those beliefs? Are children who are expressing their beliefs in a particular way going to have concerns if they know that this person believes something different to them? Obviously, in this particular case, it's around gender critical beliefs, but it could be wider, as there are lots of different philosophical beliefs covered by the Equality Act. She was dismissed for her social media content as an expression of her belief. And the key question for the courts, and it went all the way up to the Court of Appeal, was whether that dismissal by the employer is a proportionate reaction to her expression of those beliefs. And they found that it wasn't. So dismissal was not appropriate. Maybe the organisation should have looked at a warning, if not even just a caution about these things, depending on, of course, what they've got in their social media policy. Now, where have we seen this before? We've seen this kind of proportionality coming in disability cases, so Section 15 of the Equality Act, where something's happened and we take one step behind the thing that's happened, so maybe an act of misconduct, and we say, is the disability behind that, or the poor performance, is the disability behind that? And quite often it is. And then the employer's defence is for the judges to decide whether they've been pursuing a legitimate aim in a proportionate manner. So that might be managing sickness absence, it might be managing performance, it might be dealing with misconduct when it arises. So the judges are used to looking at this proportionality question. And essentially what they were saying here is that what she was saying on Facebook may be objectionable to a lot of people, but it doesn't make it offensive. The posts were not linked to the employer, so that's always a critical ingredient if you're an HR person investigating these sorts of things, is understanding, has there been any link to the employer that's been made publicly, if you like? And this wasn't one of those cases. So although people may not have agreed and may strongly disagree with what this lady was saying, that didn't make it a dismissible offence. If you've got any questions, please don't hesitate to contact me. It's adenton@refreshinglawltd, the shortened form of limited.co.uk. Thank you.